Travis County Democratic primary for district attorney. We are being videotaped, and the videotape will appear on Channel 10 some Thursday evening before the primary. We never know exactly when it will be. It's 7 o'clock Thursday evening. The program is called Taking Liberties. And with me is Debbie Russell, the chair of Travis County Democratic Women's.
No, that's not me. I'm an independent, sorry.
The chair of Central Texas chapter of the ACLU of Texas. And Scott Cobb, who is the president of the Texas Moratorium Network. Of the ACLU of Texas is our justice system. Experts have said it's broken. And our jails and prisons are overcrowded, mostly with minorities, mostly with non-violent offenders. And the system seems to channel young black men into our prisons. We will ask the candidates for district attorney first, why they are running and how you would change the system, change the DA's office, although you have all been in the office, how you would change that, keeping in mind our goals, justice, no discrimination, and so forth. So let's start. Shall we start at this end? Okay. Ms. Lundberg, introduce yourself. You have 3 minutes to introduce yourself and say how you would change the DA's office if you think it should be changed.
Well, first of all, I am Rosemary Lundberg, and I'm currently the first assistant at the Travis County District Attorney's Office. Is that better? Is that better? That's good. That's good. Just briefly, I started my career here in Austin in private practice, where I ended up taking some court appointments of indigent defendants, and realized that I needed to get some trial experience. So I joined the district attorney's office and obviously have loved the work and stayed. I've been in every major division in the office, tried cases in every division, and directed each division. And throughout my career, at every juncture, from the trial division to the major crimes, to the public integrity unit, which I directed, and then in the family justice division, I have observed and seized every opportunity to not only try the cases and handle the cases in that unit, but to change and improve the system's response to victims and to the community, and to really try to do a better job of the public's business, which is our duty. An example, in the family justice division, we learned that, or knew, that children were being over-interviewed. They were interviewed by several government agencies. They had to go to strange places to do that. And we formed a children's advocacy center. We built that with the help of the community, built that from the ground up, improvised an old house that was like a grandmother's house where children could go to be interviewed one time in a friendlier, in a softer atmosphere, and a videotape made so they wouldn't have to be over-interviewed. I was one of the first persons in the trial division to institute a training of volunteers to help sexual assault victims, which has been a particular interest of mine. This was before the days of victim services, and I trained rape crisis volunteers and later counselors at the Children's Advocacy Center to help those victims testify and to help me be a better prosecutor. One of my focus, if I'm elected district attorney, will be to continue on our core issues: violent crime, child abuse, juvenile crime, domestic violence, but also to continue to seek ways to divert youthful offenders who are charged with small amount of drugs out of the system or into treatment centers. I don't have the answer to that, but I will tell you that I've spent considerable time on that issue, working on drug court, the reentry roundtable. We lost our funding at the state jail for a period of time, and we now have restored that and are attempting to make sure that we divert more people into those treatment programs. I'm told I have 30 seconds. I'll be glad to address the death penalty issue later. I think we'll be asked that specifically. So thank you for listening to me.
My name is Gary Cobb. I'm a prosecutor with the Travis County District Attorney's Office. I've been prosecutor with the Travis County District Attorney's Office since 1990. I've been the court chief over various divisions. I'm a frontline prosecutor. These issues that we talk about here today are issues that I dealt with for years and years and years in the courtroom, and also because of my work within the community, I've been dealing with these issues for years and years and years. One perspective that I bring to this job that perhaps the other people involved in this race do not have is going out in the community and working with these people who later have family members who come through our system. It is absolutely true that most of the people coming through the court system, especially when we're talking about these nonviolent drug cases, are people who are black and brown. The things that we've tried in the past have failed miserably. We declared a war on drugs, and what it turned out to be was a war basically waged against young black men and boys and young Hispanic men and boys. To say that we don't know the answer to that is taking the easy way out. There are answers out there, but we have to have the political courage to go admit, first of all, that we made mistakes in the past. And second of all, admit that the ways we've tried to deal with it have not worked. And now to realize that we have to try something new. And we have new ideas, I have new ideas that I want to talk with the community about on how we're going to deal with some of these drug cases. That's part of it. But also part of it is within the district attorney's office, you need to have a prosecutor workforce that reflects more evenly the population of folks that are coming in there. If you have a trial court division like we do that is made up 90–95% of Anglos, but the population they're dealing with is over 50% of minorities, that is not going to give our community a lot of confidence in our DA's office. And it's not to say there's anybody at the DA's office trying to be racist in the way they deal with cases. But we all come to a job with certain biases that are related to how we're raised, related to our culture. And when we're dealing with someone from a different culture, that can very well affect the way we deal with cases. So I'm saying the old ways have failed. It's time to look at things with new lenses and come up with some new ideas. And not only come up with new ideas, but get out into the community, implement those ideas, and start making some changes.
Thank you, Gary. Next up, Mindy Montford.
Thank you. My name is Mindy Montford, and I'm running for district attorney, and let me tell you why. I have the best job in the entire world. I'm one of the few people I believe, and if you're one of them, then you join me in knowing how great it is to truly wake up every day and serve your community and get a paycheck for it. Now, it's not much, but you know what? At the end of the day, I can go home and sleep well at night thinking that I've helped somebody or changed someone's life. And that's why I'm running for district attorney. I grew up in this community. I've been here since I was 6 years old. And if you've been here that long, you know we are simply not the same Travis County that we were back in 1976. There are things that we need to look at. We cannot be afraid to take a step back and take an inventory. What are we doing right, and what is no longer working? I'm one of the people up here, I believe, time and time again at these forums, talking about specific changes. And I think it is wonderful that we probably are all up here agreeing that people who are first-time drug offenders, or maybe even repeat drug offenders, but not dealers, shouldn't be taking up a jail cell and taking something away from a violent criminal that we need off the street. But let me tell you something. We were at a forum a few weeks ago, and I believe I'm the only candidate up here who actually said, I approve and I will implement pretrial diversion programs. And that is one way we can combat that issue. But again, it's one thing to talk about everything in broad strokes and everybody out here to agree on it. But let's talk about specifics. I don't have a lot of time tonight. Maybe you'll afford me that time to talk to you about my specifics. But in case you don't, please go to my website because they're outlined. I've proposed at least 3 things that I will change immediately in this community. And the 24-hour intake unit should particularly interest the people here tonight. Because if we're going to talk about communication and outreach and looking at each case on an individual basis, the only way we can do it is by having a prosecutor available to assist law enforcement officers 24 hours a day, and not by pager, not by cell phone. They need to physically be down at the booking station telling officers on the street what crime should be charged, or if a crime should be charged at all. Right now, those cases sitting on our office floor, because we've got so many, and they stack up, and we don't get to them sometimes for weeks at a time. Is that the time you want to say we didn't have probable cause to make that arrest? So again, tonight I hope you'll afford me the opportunity to share some of these issues and specifics with you. But if you don't, check out my website. Thank you.
Thank you, Mindy. Next is Rick Reed.
Hi, pardon me. My name is Rick Reed. I've been a prosecutor for 21 years. Up until a week ago, I was with the Travis County District Attorney's Office for the past 9 years. I spent the first 12 years of my career with the Dallas County District Attorney's Office, and I have prosecuted everything from traffic citations to capital murder cases. I have supervised several felony courts, both in Dallas County and most recently in Travis County. I've also supervised the Specialized Crime Division, which includes the Public Integrity Unit in Dallas County, and supervised their misdemeanor trial division. So I have extensive experience in both the prosecution of criminal cases as well as managing employees, both prosecutors and investigators. I'm running for this office because I believe that I not only am the individual with the most important experience, but I also believe that I have the commitment to make the changes that are necessary to improve the Travis County District Attorney's Office. One of the things that I think that we need to do right up front is we need to do a better job of recruiting African American and Hispanic prosecutors. We've simply done a poor job of that to date. And as Mr. Cobb pointed out, it's important that we have a prosecution team here in Travis County that reflects the community here in Travis County. And in order to do a good job as a prosecutor, it's important that we have a diverse prosecution team. The other thing, though, that I want to do that I think is critically important is we need to expand the drug diversion court program, and I think we also need to implement an adjunct to that pretrial diversion program, because we simply have too many African American and Hispanic individuals that are going to jail, and their lives are forever changed because of criminal records that they obtain when they could have an opportunity and should have an opportunity to go into a pretrial a pretrial diversion program.
All right, thank you very much. We're going to go through some questions now, starting with some, well, I'll just start. We're going to have probably just 30 seconds on at least the first one. Charging the lowest, this is about charging the lowest level drug users with misdemeanors instead of felonies. Today, 1 in every 11 adults in Texas is already a felon, which literally makes them a second-class citizen under our state constitution. Felon status, which has disproportionately affected people of color in Travis County, means that a person cannot obtain employment or housing with most employers and landlords. Even Austin's subsidized housing authority prohibits felons, so a family with a parent who is a felon must separate for the children to maintain the benefit of a home to live in. The Texas Penal Code, Section 12.44b, allows prosecutors to charge a person who is caught with less than a gram of an illegal drug with a misdemeanor instead of a felony. Well, you use your prosecutorial discretion to charge these low-level drug users with misdemeanors instead of felonies if you are elected to Travis County District Attorney. And we can just do some short answers if you would like to follow up. We could go till a minute. Let's just try for 30 seconds.
We're going to start in the second
Let's
order.
start with Rick, yeah. That's a good idea since the microphones are already set up. Rick?
All right. Undoubtedly, that's, I think, one of the things that we have to look at beyond the pretrial diversion program. I think that the first option should be to divert those cases into a pretrial diversion program, and the decision to charge a crime should only be a secondary matter. But certainly if a case is deemed to be inappropriate for, pardon me?
30 seconds.
If a case is deemed to be inappropriate for pretrial diversion, then we need to take a good hard look at charging it as a misdemeanor rather than a felony.
Mindy?
Can I just clarify, you said first time offender? Or just in general?
Let's see. The penal code allows for in general from what I read it, and so.
I didn't know if your question was specific. I mean, here's the answer. We do that right now. We have that discretion, and we do it every day in the appropriate case. I mean, you've got to take a look at the case. If it's a first-time offender, of course you're going to look at alternatives. But if this is someone who's repeatedly arrested, well, we have another problem we need to concentrate on. But as a prosecutor, I do wonder, at some point, are the police going to just say, throw our hands up, and we're not going to make these arrests because you aren't going to prosecute it? That's my only concern with that. But I'm not opposed to that, and I've done that before, and I will continue to do that on a case-by-case basis, absolutely.
Well, let me just say that there's a whole bunch of first-time felons out there who don't know that we've been doing this for a long time. Everybody apparently is not getting the benefit of that. And I absolutely would do, but you got to approach this from a different way. It's not a matter of making a lesser crime out of a felony. It's about doing something different with it so you don't make a crime out of it. I know Mindy has a good point. We don't want to get to the point where the police say just throw their hands up in the air, but what we do want to do is get to the point where the police say we're going to quit making these big sweeps and going after these little people out there with crack, one rock of crack in their pocket. We're going to move up to the next level and go after the ones that really affect the drug market, that is the dealers on the mid-level and upper level.
And I probably agree with what Gary said more than anybody. We do misdemeanor reductions all the time now, and it's appropriate in appropriate cases. But let me make something real clear. Drug court is a diversion program, and you can't get enough drug courts. But I also have said and say here tonight, there are things that we need to do that we haven't even thought of. And I'm not opposed to that, and I have worked in the community on this issue. So we've also started a juvenile drug court. Drug court is a very effective model, and it is a diversion. Those people are not convicted. But there are a million ways to do this. The police are making too many drug busts on one rock cases, and we've talked with them about that, but the answer is not to tell the police not to do it. The answer is to get to the problem and to try to figure out why people are just getting off track.
Okay. A couple of follow-up yes or no's on this one. There's two. One of them, HB House Bill 2391, for those of you who don't know, was passed in the last legislative session, allows police to give a citation at the lowest level marijuana possessors instead of arresting them and taking them to jail and clogging up our jails and system. Many large and small jurisdictions in Texas are already using the law, including the Travis County Sheriff's Department. But the APD, unfortunately, has not yet implemented their program, which they say is in the works. But my question to you folks here is, will you counsel APD? If it's not up and running by the time one of you is elected, will you counsel them to implement that program? And the second one, will you prohibit consent searches and arrests for Class C misdemeanors? You can answer those two.
Well, fortunately, we don't deal with a lot of Class Cs. I don't have any, and I would counsel any officers that approach me about implementing that problem.
Good.
I think the police are already talking about the consent search issue.
So if I understand your question correctly, yes and yes.
Excellent, excellent.
One of my many strong points.
Since when? Yes, I will counsel with APD. That's one of the big things I've been talking about is communication and working more, collaborating more with our agencies, including law enforcement. And if they are indeed working on the consent issue, then of course I would continue to work with them and support them on that.
And I would do the same. I would certainly counsel the Austin Police Department to issue citations in marijuana cases involving small amounts. But I would also counsel them to discontinue the practice of consent searches involving Class C matters, primarily because it's in my belief that those are searches that disproportionately affect people that are in the lower socioeconomic strata as well as minorities. So I think that we ought to do that.
Thank you. I'm glad that wasn't a contentious question. While we're on that subject, thank you for bringing that up, Rick. Wanted to point out a very recent study, Justice Policy Institute, national organization, just came out with a study in Texas related who is getting profiled for illicit drug use the most and in which counties. Unfortunately, Travis County actually rated second highest in the state of Texas, and in that case, that they are 31 times more likely, African Americans are 31 more times likely to be incarcerated for drug offenses than whites in our county, 31 times. In Dallas, it's I think 19, in Houston 9. We're way higher in Travis County. You got to ask some questions there, right? Even though blacks and whites, just so you know, do use drugs on the same scale. So it's not how often people are using them, it's how often people are getting busted for using them. So there's an extreme racial disparity, and some of you have already mentioned some pretrial diversion programs and the like, and I want to invite you to talk a little bit more in depth and in detail about what kind of alternative programs that aren't there now, but you would like to see implemented in the District County Attorney's Office, considering these staggering statistics.
Well, I think you also need to realize, and I know this study, it's not just arrest, but it's also incarceration. And that's part of the issue. So we are not only arresting more, we are incarcerating more minorities. One plan that I have is to follow what they call a High Point Plan, H-I-G-H point. It's from a city in North Carolina. What they came up with a very unique, innovative way of dealing with open-air drug markets. And what they did was they would go out and videotape or shoot pictures of some of the dealers located in these drug markets. And you have to understand what we're talking about is people dealing small amounts so they could get drugs to use for themselves. We're not really talking about dealers. We're talking about dealer users. So that's one way to go about approaching this problem. I don't have enough time here today to talk to you about all the details of the High Point Plan. But that's one way of doing it. And what that also involves doing is having the community itself directly involved in treating this drug problem, which is in reality a health problem. But it's also getting community services involved in it so that we don't just pick somebody up and then release them for them to go back to that same environment to commit the same crime over and over. We follow them through and make sure that they're getting services as part of the treatment.
And again, collaboration is key there, and I think that's right. You've got to break the cycle at some point. But having said that, again, I go back to the 24-hour intake because I think it encompasses so much of what we are talking about here today. And you may be sick of hearing me say it, but folks, this is what we need. I mean, we're talking about incarceration, and disproportionately. And if that's the case, then perhaps we need prosecutors trained and experienced making those calls before the arrest takes place. And I know we've had some other ideas of night court. I'm not opposed to that, a 24-hour system where we're down there granting pretrial diversion or not charging a felony if it's an appropriate case, but doing it before somebody's been incarcerated or before it gets to the felony courts and the grand jury.
The one thing that I think the past probably 100 years has proven is that incarcerating people for drug usage just simply doesn't work. We have managed to make felons and, for that matter, misdemeanor criminals out of a large segment of our society by simply making the use of certain drugs an offense. It has not worked. What we've done is we've clogged up our criminal justice system with cases involving people that have been charged with drug offenses. We've clogged up our jails. We've clogged up our prisons. And part of the problem with that, aside from the fact that we are criminalizing, making criminals out of people that otherwise would not be, is we've lost the space for the truly violent criminals. So I think that this is basically a three-pronged problem. We've got to work. It involves the community on the one hand, but it also involves the police and the district attorney's office. And as far as the police and the district attorney's office are concerned, We've first of all got to recognize that there is a problem here. I myself was shocked when I saw that statistic a couple of days ago, about 31 times more, that African Americans in Travis County were 31 times more likely to be incarcerated for drug offenses. I think it's shocking. I think it's deplorable. We've got to do something about that, and one of the things that I think we can do right up front is we can work with the County Commissioners Court and with the legislature to establish more funding so that we can expand our drug diversion court. That's a program that's focused on treatment first and foremost, and that's really where these efforts have to lie.
I don't know how many times we can say more diversions, more diversions. We're all saying the same thing on that. And I'm not hearing anything particularly new. I can't tell you that about the High Point program, but I will tell you that our nuisance abatement program is working on open-air drug markets along with the police, and it is true that we need to take out the availability, which will help some. But what all of us are talking about is trying to figure out how to keep these young folks from coming into the justice system at all, and to divert them and to make sure that they don't get arrested at all. Or if they do get arrested, look, what happened to us when we developed the rocket docket to try to expedite these cases so they wouldn't be in jail, is we knew that we were going to hear from the very neighbors who had called the police in the first place to talk about the drugs that were being dealt on their corner. And it only took a matter of time before those same neighbors were complaining that we were going too fast. We had an overcrowded jail because we were trying to move these people into other types, get them out of the jail. And all of a sudden we created this chaos back in the neighborhoods who had complained in the first place. So there are many problems attendant to this issue. And I'm saying to you that they're working in the community with new ideas, High Point perhaps, but videotaping open-air markets, that's great, but we can't have enough diversion programs to try to keep these folks from ruining their lives. That's the point.
Okay, we're going to have two more questions, and then we're going to open it up to the two more prepared questions, and then open it up to questions from the audience, and then we're going to have some more questions later.
Will you make sure you say how much time each candidate has?
Okay, well, for this question, the next question is going to have to do with the death penalty, and I'm going to ask maybe a couple of minutes response for that. And in 2007, the Texas accounted for 62% of all the executions in the United States, and in 2007, the South, the states that comprise the southern states of the United States, executed 86% of all people in the United States. And so my question as a representative of a progressive anti-death penalty organization is, do you think that, would you support, in light of the legacy of where the death penalty is being implemented today in Texas and in the Old South, this is really a legacy of the Old South. And I think Travis County is a little bit different from the Old South. So my question is, would you support a moratorium on using the death penalty, meaning seeking the death penalty for people charged with capital crimes, and would you instead use life without parole as an alternative? And the second part is, would you support a moratorium on seeking death sentences, dates for executions for people who are already sentenced? And my understanding is that the district attorneys are the ones who request the death sentences from the convicting court. So it's all one of the big disparities that some counties like Harris have so many executions is because the district attorneys down there ask for execution dates. So two-part question: would you support a death penalty moratorium on new death sentences, and a death penalty moratorium on convicting people who have already have sentenced to death, on dates for those? And that's beyond what the Supreme Court has already implemented as a moratorium nationwide. Right now, nobody in the country can ask for and receive and have a death sentence carried out because there's a national moratorium. That may be over in a few months. So this is beyond that. This is saying even when the Supreme Court says it's okay to begin maybe new executions, would you support not asking for those execution dates beyond that? And I think Mindy hasn't been first yet, so we'll let Mindy go first.
I like the way you saved that question for me. Thanks. Now, and many of you know I've been asked this a lot, and I'm not going to say I'm going to declare a moratorium, and I'm not going to apologize for that, because let me tell you something, that's not the job of the DA. I'm entitled to have my personal opinions on various laws. There are a lot of laws on the book I don't think should be on the books. That's not my job as the DA. As the DA, I am charged, and I take an oath to follow the law. You want to ask my opinion on the death penalty? That wasn't the question, but I'm happy to answer that later. But as district attorney, would I declare a moratorium? No, that is not the role of the district attorney. Having said that, I worked on the life without parole that you now have on the books today. Senator Lucio was the sponsor of that bill. I worked for him. I drafted the language that is part of the law that is there today. I worked tirelessly with both sides of that issue to get that passed, regardless of how you feel about the death penalty, whether you support it or whether you're against it. Life without parole is a very good option. I'm very glad it's on the books, and I will seek life without parole when it's an appropriate case, but it is not my job as the district attorney to declare a moratorium.
First of all, with regard to seeking the death penalty in cases that are currently under review or could come before the district attorney's office in the future, I would not. This is something that I have wrestled with for quite a number of years, dating back to when I first made application with the Dallas County District Attorney's Office for employment as a prosecutor, and I was asked that hot button question. And I told them the truth that I did not favor the death penalty, and that if I felt that I was being asked to do something that I could not in good conscience do, then I would notify my superiors and we would act accordingly. And I was quite frankly surprised that they hired me, having given them that answer. As I say, I have wrestled with this issue for a number of years. I recognize from having prosecuted criminal cases for 21 years that certainly there are people that commit crimes that, in my judgment, merit the death penalty. The question, though, is, would I, as district attorney, authorize the office to seek the death penalty? And I think that when you're dealing with that issue, you have to get beyond the emotional question of whether or not a specific crime merits the death penalty. And for a whole host of reasons, I believe that it's a mistake for the Travis County District Attorney's Office or any other district attorney's office in the state of Texas to seek the death penalty, particularly now that we have life without parole. As far as a moratorium on setting execution dates, I would favor that.
I think that anyone who has a conscience and has been a prosecutor for a while has struggled with the death penalty issue. I know I certainly have. I helped implement the current process that's in place at the Travis County District Attorney's Office, which, by the way, was written up in Time Magazine in an article called Guarding Death's Door. And I invite you to read that. It talks about our capital murder review committee. But in the end, the district attorney makes that discretionary call. We have very few people on death row, 5, I believe, and 1 is under review now. I simply cannot pledge to never seek the death penalty. I know from experience that the minute I make a promise like that, something comes up, and I'm sorry for making promises. What I will promise, because we have been very successful in using consecutive sentencing, particularly in multiple deaths, and now life without parole. We've been very successful in guarding the public interest and taking care of the public safety and getting these violent people off the street without seeking the death penalty. And so we seldom do it. I will continue to look at every case. We only have even said we're seeking the death penalty in the very most egregious case where a person shows possible danger, not only to the citizens, but perhaps even incarcerated. But I don't take pledges or make pledges like that. I do support, of course, a moratorium now until the U.S. And I don't think that's exactly what you're asking, but I would certainly couldn't in good conscience seek an execution now of any inmate until the U.S. Supreme Court would.
But the question was after, beyond that.
Like I say, I would just continue to look at each case individually.
Jerry?
I think it's clearly it's a very complicated issue. Until I turned 30, 31, I was very, very opposed to the death penalty. I didn't believe that the state should be involved in the business of killing someone else. But then I started following this case out of Houston where these 4 gang members had come across these 2 girls who were on their way home from a party. And as part of their gang initiation, they raped these girls, violently raped them, took their shoestrings off and strangled them to death, and then went and continued their party. And they made me start thinking, and none of them had mental health issues or anything like that. They were just, they didn't care about human life. And they enjoyed the agony that they caused these girls. And that made me start thinking about how maybe those people who could inflict that kind of harm not only on those 2 young teenage girls, but also the kind of harm that they inflicted on their families, maybe they didn't deserve to continue living. And maybe the state did, under those circumstances, have a right to take their life away. Now, I prosecuted, I guess I might be the only one on this panel who's prosecuted a death penalty case. A man who used a knife to butcher 2 women because a woman wanted him out of her house. Prior to that, he had killed another man with his hands. In between that, he had tried to kill 2 other women. I wonder if that man should be allowed to go to prison where he could come into contact on a daily basis with others and perhaps kill others. Let me tell you a secret about life without parole. It's just a feel-good thing. See, what life without parole does, it allows a person who's not on death row to be out in the general population. That's mingling with the drug users who are there, with the people who are there for DWI or theft or any other kind of felony. So if he wants to kill again, he will kill again. Not just people who are in the general population, but people who are nurses, librarians, guards. That's the kind of access you have when you're there for life without parole. And the truth is, no one gets out of prison after that 30 years, which is what it was before they changed the law. The law was just to make us think all of a sudden we're safer with that option, but you're not safer. And what jurors look at is the person a continuing threat to society? And that's the important thing. But because of that, because if that person is a threat to kill again, I would rather, as an act of self-defense, we take that person's life than to have that person take someone else's life.
Thank you, Garrett. A little housekeeping. There's a lot of people that are trying to sneak in. There's a chair here, 2 chairs over there. If somebody could take it upon themselves and remove a table or 2, we could get 3 or 4 more chairs right where that table is. That would be really awesome. Yes.
Turn it up. It's real hard to hear back here.
We need some more sound.
Well, they need to talk closer.
We need to talk closer to the mics. Okay, that's the trick, says the sound man. All right. Another contentious issue from police accountability standpoint. In several cases, well, in many cases, I've only been in this gig a few years now, but from what I hear, it's been going on a long time. We have a habit here in Travis County. We just can't prosecute officers, police officers, no matter how devastating the evidence. In 2003, Michael Olson was caught on videotape. The Texas Lottery Commission has that video camera outside, assaulting somebody, and Jeffrey Thornton. And he was found guilty for it, but yet they still wouldn't indict him. Ronnie Earl wouldn't see it through. Yet, of course, he was put back on the force just to shoot Kevin Brown last summer. So I'm sorry, but you can thank Ronnie Earl for that. So, charging police officers with crimes when they actually commit them. The evidence is routinely excluded in a lot of these cases, and witnesses are not brought forward to testify, other than a police report being submitted and perhaps the presentation being given by the investigative detective. And no alternative charges are presented usually, other than intentional murder as the charge. So that's why juries are so afraid to indict. They could bring them up on charges such as criminal negligent homicide or the like that would actually be a little bit more palatable for juries. We want to know if you would be willing to make any specific changes in order to prosecute officers who have done wrong against the community.
How much time?
And we're going to have 2 minutes on that. Rick, let's start down there.
All right. Yes, I would make some specific changes. First of all, I would establish a special unit that would be charged with the responsibility of prosecuting cases of this nature. It's my belief that public officials, whether they be members of the legislature, state senate, or police officers, ought to be held to a higher standard than our ordinary citizens. And if a public official commits a crime, that crime ought to be investigated, and if the evidence is brought forth that that particular individual did in fact commit the crime, proof beyond a reasonable doubt, it ought to be prosecuted vigorously. So I think that we need to establish at least a special individual who is charged with the responsibility of doing that. Because anybody that's ever prosecuted a police officer recognizes that there's a lot more that goes into that case than prosecuting any other type of a case. Juries, unfortunately, tend to give police officers more fair trial, quote unquote, than they do ordinary citizens. And it's imperative, in order to do a good job prosecuting those cases, that the prosecutors be familiar with how to go about prosecuting them. So that's one of the changes that I would make.
I've spent a lot of time recently thinking about this issue because here's what's happening. In the community, we don't explain the grand jury system. We don't reach out and talk about the things we bring to the grand jury. And because of that, there's a distrust, understandably. And one of the things that I have proposed already on record is to have a street response integrity crimes prosecutor. Now, you may hear later we already have one of these, but I disagree, because can you name the person who takes those cases right now to the grand jury? Y'all know her name? Okay, there's one person who knows the name. Anybody else?
Greg Cox.
Greg Cox doesn't really take those, but here's my point on
When
that.
I was on the yoga shop.
Okay. Well, here's my point on that. You need to know who that street response prosecutor is by name. And that person needs to act sort of as the model we've set up in this community as the police monitor. That person needs to be not assigned to the police station, not officing in the DA's office. He or she needs to be an experienced prosecutor out on the street, talking to neighborhoods, talking to the community. You need to build a trust with that person so that when that person gives you his or her word or takes a case to the grand jury, regardless of the outcome, you believe the system went the way it should have. Secondly, there needs to be a laundry list given to prosecutors that every single case you take to the grand jury, you will produce the following items. That is a must. And when a prosecutor does not comply with that, it goes back to the district attorney herself.
Well, I don't think it's a communication issue, or I don't think it's a laundry issue. I think it's a prosecution issue. And so here's a perspective I bring in here where I might have a little bit of an advantage. I'm used to prosecuting tough cases. So I'm used to, from very early on, when I get a case, looking at it from a prosecutor's point of view who's in the trial court every day prosecuting tough cases. Not sitting around talking about tough cases or talking about how we should administer a tough case. I'm talking about prosecuting the cases. So when you have a police case, and you have somebody from the very beginning looking at it as you would any other crime that may be prosecutable, then that gives you an advantage because you lead the investigation from a prosecutor's viewpoint. When I met with the Austin Police Association, prior to getting their endorsement, I said to them, if an officer simply shows a lack of judgment, a poor judgment in a situation, I'll be your best friend because I can understand how in a harried situation, an officer may show poor judgment. But if an officer does something that is a criminal act that causes someone to be hurt or killed, then I will be your worst enemy because I will approach it from a prosecutor's point of view and I know how to prosecute cases. After hearing that from me, the Austin Police Association gave me their endorsement. See, one thing you sometimes don't realize is the police want to know that we will prosecute cases aggressively and, most importantly, fairly. And that's something I would bring to the prosecution of police officers who are charged with cases.
Well, I believe some of it is a communication problem, and I think one of the problems we continue to have is that, first of all, people don't believe that grand juries are independent, and they are. I mean, we do present these cases straight up to a grand jury and tell them that it is their judgment on what should happen to it. It is a communication problem if a grand jury no bills, because the public can't really know necessarily what was actually said in the grand jury because it's a secret proceeding. I believe the new police chief is on the right track with some of the things that are going on. I've communicated with him about that. We have 2 lawyers in Los Angeles right now working with the police department on a new model that will be more transparent. It will spread out the investigation piece, so it's not like we're ignoring this problem. And I know about tough cases. I was urged in the past to prosecute or push for the prosecution of an officer who was charged with aggravated sexual assault, who was going to be charged with aggravated sexual assault. But he couldn't be. He was charged with official oppression. It was only because of my urging that that case went to trial at all. So it's not just use of force cases, it's other misconduct cases. And that case was difficult to prosecute. It was a tough case. We prosecuted it. We got a conviction. We got jail time from a judge who ordinarily didn't give jail time, only to be reversed by the Court of Appeals. So, you know, there are all kinds of evidentiary issues that we run into, but we are presenting these cases fairly. We need to try to be as transparent as possible. We need to spread out the investigation of them, and we need to communicate better with the community and get input from the community about what happened in the grand jury.
Thank you. We're going to open it up to audience questions now.
Tom DeLay, the Ronnie Earl's office, your office, brought the Tom DeLay issue before 3 grand juries, and yet Julie Schneider, I believe that's her name, the police officer that killed Daniel Rocha, 17-year-old, shot in the back, unarmed, face down on the ground, was quickly brought before 1 grand jury, and that was it. So that's not really about not understanding that the grand jury is a private process. It's really about the actions that Ronnie Earl's district attorney's office took. And some in the community, I think, believe that that is not justice. And I ask you, will you continue to reflect that tradition, or what will you do different? Do the grand juries reflect the community? What would you do?
Let's try for 30 seconds.
Marissa, first of all, no police officer cases ever go quickly before a grand jury. They have to develop those cases, get the evidence together. And the Julie Schroeder case was thoroughly presented with experts and with all the witnesses involved. You have to remember that the Tom DeLay case wasn't just Tom DeLay. That investigation of the November 2002 elections was spread out, and there were several parts of it: corporations, the Texas Association of Business, Texans for Republican Majority, as well as others. I think that that's somewhat a misrepresentation of the facts.
Anyone else want to speak to that?
I'm just a fan of respecting the grand jury's verdict. I mean, no matter what the case is. If it's Tom DeLay or if it's, in the case of Julie Schroeder, I think that you get your one shot at the grand jury. I don't think you should be shopping around.
And I would like to speak to that just briefly. I think it's easy to say, in theory, that the state ought to have one shot at the grand jury. The problem with that is, I have observed in my 21 years as a prosecutor that there are instances where a grand jury, for whatever reason, does not pay close attention to the evidence that's presented, and they no-bill a case that otherwise should have been indicted, in my judgment. And if we simply take the position that it's one shot at the grand jury, and we present a police misconduct case to the grand jury, and they no-bill the case, and we've looked at the evidence as prosecutors, and we're confident that that's a case that we can prove beyond a reasonable doubt to a jury, I think that we're doing a disservice to the community if we simply turn our head and say, well, the grand jury made their decision. I think that there are going to be cases inevitably where the district attorney's office has to say, well, we need to present this to a second grand jury and see what they have to say.
Who had another question?
Does anybody on this panel support our Texas right for an examining trial before a magistrate? Because it would be a simple solution to get rid of a lot of cases that are clogging the higher courts. And we are guaranteed that under the Texas law, and your predecessor, Mr. Earl, promised 30 years ago that everybody in Travis County would have the right to an examining trial. But if an examining trial is scheduled, that case is rushed to the grand jury, the next grand jury that meets usually the next day, so that the person cannot have an examining trial. Thank you.
About examining trials. I didn't know Ronnie promised that 30 years ago. I forgot to jump in it. You know, I'm not sure that solves the problem you're talking about, though, because examining trials happen in the system past what we're trying to accomplish when we talk about pure diversions. Perhaps we could talk about examining trials being a way to unclog the system, and I'm not ruling that out, but it is just a probable cause hearing, which we could do otherwise. But I really don't think that speaks to the pretrial diversion issue.
Any other unique perspectives on that issue?
Yeah. I moved here from Katy about a year ago, and I know Mindy has an ad about homes being burglarized, and I live in Travis Country, and my home was burglarized, and I have left messages on who I now know as Mr. Cobb and a few other district attorneys, and the burglar was convicted by a grand jury. He stole over $30,000 out of our home, left literally his driver's license, and we actually, and I guess now I'm understanding, had he been black, he was actually white, they will not extradite him from Atlanta. He moved and took my stuff with him. We provided him with an address, and I mean, it even came down to the fact that the district attorney's office or certain supervisors decide whether an extradition is added. And offering to pay, and then finally coming up with a price for me to pay for his extradition at $3,200, and then deciding whether or not it was legal to do that. In short, he's running free in Atlanta. We know exactly where he is. And I actually stood in front of the Harris County, that's where I live, the district attorney's office with the burglar's outfit on and this sign saying, I can actually rob you and leave the state, and they just wait for you to re-enter Texas to get you, even if they know where you are. What will you do about adding extradition to felony crimes, even burglaries, if it exceeds $25,000?
And I wanted to actually add, I meant to ask a follow-up question to the no bill question earlier. In line with that, somebody asked if we could ask you guys if you would extradite Stan Nee for some of the police officers that went unpunished and didn't get fired and didn't get convicted.
Well, I'd like to take that question because I know what it feels like to be burglarized. It's not fun. That's your stuff, and it's the most violated feeling when you walk in and know somebody's been in your house uninvited, sorting through your stuff. And then to have somebody tell you we're not going to prosecute them, and we know who they are. In my case, they couldn't find him. In your case, they know who he is. Left his driver's license. We absolutely need to extradite him, without a doubt. And I would support that wholeheartedly. Let me tell you something else. I had convicted somebody of aggravated sexual assault of a child, and he fled this jurisdiction. We still haven't found him, but I have continued to fight to get him on America's Most Wanted. We don't know where he is, and I'm still fighting for it. You know where he is. We definitely need to extradite in those cases, absolutely.
How come you haven't extradited him?
Oh, we have one question in the back, Deanna. I know you've done
Well, actually, I have a couple of comments to make, and then part of the problem, well, there were several problems. One is that they wouldn't let us ask questions.
Two, when we did finally insist upon them that we wanted to ask questions, they said write it down. So we'd write them down, and then the questions weren't asked the way we were asking them. The third problem was that there were three of us that really felt that we needed to see the two confessions of Michael Scott and Robert Springsteen. And so we wanted to see them so we could compare. And we asked over and over again, and they said, we don't have them ready yet. They're being, what do you call it, they were being transcribed. The videotapes that the media got, we asked for the videotapes because we knew they existed, and they wouldn't let us see them. They said they're not ready, they're kind of garbled and blah, blah, blah. So we never saw some of those things to be able to really make some good decisions about what was going on. Now, the next thing was that what they would do is that, not those two on this case, but some of the other DAs, a couple of them were women, and I can't remember their names anymore, because it's been almost 10 years, would say, well, you know, this grand jury's got, you know, 100, they did 100 yesterday, and, you know, we're kind of falling behind, and so some of our grand juries were just really happy because these guys were our friends, and we wanted to do them a favor and get these people indicted. So we would end up indicting just, okay, what's the next one? Next, okay, next, in competition. And I don't think that we thoroughly saw some of these cases and got enough information to really make those kinds of decisions. So the concern is, please work with your DAs to not be buddies with your grand jurors, because you become a part of them, and you want to do what they think is right without really taking seriously the responsibility of a grand juror to make informed decisions. So I want to see what you guys are going to do about it, because it's going to really make a big difference in this community. And I wonder how many, and I wonder about the process too, about the appointments of grand jurors. It's incestuous. I know several families who have gone all the way 2 or 3 times around, the daughter, the mother, the mother-in-law. And then they come back in another year, the daughter, the mother, you know, in 3 years. So it's incestuous. So please.
Bring it to a challenge or a question.
It's a question and a challenge to ask you what you do.
Rephrase it. You're
Familiar with the system you talk about of grand jurors not being able to ask questions. I wouldn't condone that, and don't. If they were questioning a witness before the grand jury and asked you to defer questions, that's fine. I've seen that happen before. But those questions of grand jurors need to be asked. So I simply don't condone that practice. I wasn't there, so I didn't see it. I think there is a healthy independence that grand jurors need to assume and be in that role always. I think that after grand jurors and assistant DAs spend some time together, they're friendly, but I would always hope that there was a healthy independence between the prosecution and the grand jury, because it's what makes it credible.
Any other comments?
I do, because I know that recently up here, we were just told that a laundry list might not be the answer. Let me tell you something, that laundry list, what we're talking about there, that's a casual term. There's protocol and policies and procedures. We need guidelines. Our grand jurors, our prosecutors who go before the grand jury need training on how to present a case. And we need to let the community, the media, and the prosecutors and the suspects know what the protocol is, and exactly what we promise to present in that grand jury and the manner in which we're going to do it. And once we have that training and that protocol in place, then I think we can start building trust again.
And let me just say again, it goes back to training. You know, you train your prosecutors to be better prosecutors. We don't do a good job at that. I'm sure your experience probably was you had some very good prosecutors come through who knew how to present cases and did it in a fair and balanced manner. And you had others that came through and kind of rushed it and didn't present as much evidence as you wanted, and you felt you had to rush also in order to get through with it. But it's all training. It's not about laundry. It's not about protocol. It's about training prosecutors to be better prosecutors at every stage.
Rick, anything from you?
Well, as far as the issue of whether or not you were presented with the evidence that you requested, certainly if a grand jury requests evidence that they are legally entitled to receive, the district attorney's office ought to provide it. Now, as far as the depth in which a grand jury can go into a particular case, unfortunately, because of the fact that grand juries are charged with the responsibility of determining probable cause, and they do have so many cases to deal with, it's literally impossible for grand juries to devote the time that they often would like to do any individual case. So there it becomes incumbent upon the individual prosecutors to make sure that when they present a case to a grand jury, that it's not simply a case where they have sufficient evidence to prove probable cause, but it's a case where they have sufficient evidence to prove beyond a reasonable doubt that the individual charged did in fact commit that crime.
Okay, we have several from the...
How would you, if elected, try to depart from or fix kind of the tainted ethical legacy of the DA's office that, for instance, railroaded Lucretia Murray into murder charges when she was a mentally disabled girl charged with murder when she was manipulated into confessing to a crime that she didn't commit? So,
Do you have some suggestions on that so that we can, on how they would do that? Areas in which they should explore, or do you just want to leave it open?
For instance, cooperation with defense would be one, because, for instance, a number of cases that my organization has worked on has shown a number of cynical strategies on the part of prosecution, suppressing evidence in witnesses and other bits of evidence from defense, particularly court-appointed defense attorneys who often lack the experience and the resources to make those kinds of arguments.
So yes, we would cooperate with the defense. I believe that the best I can do on that particularly complicated question is to say that, you know, the law says it's the duty of the district attorney not just to convict, but to see that justice is done. And I take that duty very, very personally. I believe it's my job as elected district attorney I owe a duty to every defendant to conduct fair trials, to not overreach. I do not know of instances where we have ever suppressed evidence in our office, and if I knew about it, that person would be taken to task. I know those kind of allegations come up frequently, but I think we need to ferret that out and see what really happened. I think we owe a duty to be fair and just and to review cases and to seek the truth. We also owe that same duty to victims and to the whole community to present our cases with integrity and in a sophisticated professional way. And that means cooperating with the defense at every juncture.
I think that sometimes just because you believe that you know the facts of the case and you do discovery on the case and those facts aren't there to support a defense case, that doesn't mean that we're hiding those facts. It may be that those facts just don't exist. So sometimes where groups that you represent think that we're hiding evidence or being manipulative about evidence or being sneaky, maybe it's just that those facts don't exist. For instance, you suggested today that Lucretia Murray is a mentally disabled person. That's a new fact that I haven't heard anybody suggest before. All the evidence that came out at trial was that she was not at all mentally disabled. That was the evidence that came out at trial. Maybe in the meantime, over the years, some other evidence has developed, but even that's not true.
You know, clearly if you're feeling that and you're viewing that and you're talking about it, then there's some sort of disconnect with the way we're doing things. And I'm not going to suggest that we are suppressing any kind of evidence there or trying to be sneaky. And let me tell you, I can attest everyone up here has very high ethical standards at this table at least. And if that's going on, then the district attorney needs to know about it and they need to be terminated. Because let me tell you something, it is embarrassing when you open the paper this week or over the weekend. There are 2 stories on prosecutors in this state who are acting as criminals. That taints us all. And what Rosemary said is true. I mean, we are here to seek justice. And as trite as that sounds, and you're like, oh, here we go again with that quote. Well, let's think about that for a minute. When we have these prosecutors violating the public's trust, it makes us all look bad. So clearly, I respect the fact you have that opinion. I'm not going to say I necessarily agree that that has happened. If it is, number one, the DA needs to know about it and take measures. But number two, what that says to me is that we're not working with you and the defense possibly as best we can to be visible, accessible, and quite frankly, transparent.
I think there are a couple of, I think there are a couple of ways that you address the issue that you raised, and I think first and foremost, it comes in at the hiring stage. When you hire an individual as a prosecutor to work for the district attorney's office, it's imperative that that individual understand at the outset that hiding the ball, that suppressing evidence, that deception, lying, anything of that nature is simply not going to be tolerated. That prosecutors will be held to a higher standard than any other lawyer in the Travis County District Attorney's Office. So I think that's the first thing that you have to instill in prosecutors when they are hired on. Secondly, I think that if you establish a good, solid, open file policy so that defense lawyers have an opportunity to examine the evidence that's in the state's file, I think you can go a long way toward avoiding the sort of things that you described.
All right, go ahead, man in the green shirt. We can make a quick question and we're going to have 30 seconds.
To be the worst piece of juridical misconduct by the Travis County District Attorney's Office in my lifetime took place in the early 90s with the Little Dudes Daycare prosecution out in Oak Hill, wherein there was the satanic child molestation, witchcraft, bullshit, charges that sent the Kellners off to jail for the rest of their lives. Two of you, I believe, were working in the District Attorney's Office at that time. I'd like to know if your fingerprints are on that case in any way, and if they are, why do you think that you deserve to be a district attorney? Secondly, if you were in the district attorney's office at the case, why did the Travis County Reserve Sheriffs get probation while the Kellners got 45 years for doing the exact same satanic witchcraft bullshit? And finally, for all four of you, why are the Kellners still in prison? And if you aren't willing to get people out of jail that your office sent off for witchcraft, what on earth is going to prompt you to correct a miscarriage of justice?
Start that one off.
Well,
Familiar with the case?
I think I better, because
Take the
I
microphone.
think you're talking about the Fran and Dan Daycare Center. Is that what you're talking
Little
about?
Dudes Daycare out in Oak Hill, Kellners.
Then I don't know what you're talking about. I mean, I remember a daycare center case years ago where the evidence was controversial, certainly. And the case was taken to a grand jury, and it was taken to a jury trial by, boy, this is Brian Case, maybe? It was tried to a jury. The jury heard the evidence. That's all I can tell you.
So your fingerprints aren't on it?
No, my prints are on it because I remember it, and I bet they don't. So I have to let them speak for themselves on it. I mean, I think that case was in the Family Justice Division when I was the director.
Just like nobody else is stepping up. Go ahead and your question, I'll go to this, and then we'll go back to the back of the room. Go ahead, ma'am. Are you wanting the answer? Or?
The answer is if you aren't going to get, the question in part is if you aren't going to get people out of jail, your office sent off to slammer for the rest of their lives for witchcraft, what on earth will prompt you? Are you going to do anything to get the Kellners out?
Well, I think that if there's any evidence that a person has been wrongly convicted, I think I speak for everybody up here, and that we would follow that evidence anywhere it would lead and do everything we could to get a wrongly convicted person out of prison. That's an easy one.
So bring that evidence to their office, and they'll be happy to look at it, I'm sure. Okay, ma'am.
Hi, I'm Linda Yates, and I'd like to know if you would accept a plea bargain for a violent crime. Violent crime being murder, rape, assault, and robbery. And my other question is, do you have enough prosecutors at Travis County to do the adequate job? And if you don't, what would you do to get more? Thank you.
Well, I guess I'll start with that one. The term plea bargain, we accept plea bargains on almost all cases. Plea bargain being an agreement that the state thinks is a fair agreement and that's acceptable to the defense or defendant. So there's some levels of what is an appropriate plea bargain. I think that we do less plea bargaining, we should do less plea bargaining on violent cases. The ones we should be plea bargaining to get out of the system are the non-violent cases, especially the low-level drug use cases. And I'm sorry, the second part of that was?
Do you have enough people in the prosecutor's office today to do the job you need to do? And if you don't, what would you do to get more?
I think we do have enough people to adequately do the job of seeking justice and looking out for the public safety. If we had more prosecutors, and I think we can work on getting more prosecutors, because you can get grants for more prosecutors. You also show the county commissioners your need to have more prosecutors. If you can show them where you want to focus those resources at, because we do need to focus resources on community prosecution. Now, we talk about community prosecution in our office. Everybody thinks it's a great, great idea, but our community prosecution consists of having one community prosecutor downtown to work with the Downtown Alliance, and one that's recently been placed out in Southeast Austin. That's not really true community prosecution. We need to have more of that because that will help us be more safe by having less crimes.
Any other quick follow-ups?
Do you want to hear from all of them? I mean, I think plea bargaining unfortunately is a necessary evil. None of us like to do it, but I think with the system as clogged as it is, we really do sometimes, unfortunately, with the victim's consent and with the agreement of the defense, we do have to entertain those plea bargains. And sometimes if the defendant's willing to say, you know, I'll take 40 instead of 50, well, that makes sense, of course. To attract more DAs, I mean, one thing, I know you're saying, do we have enough? And I think we do, but I think we can look at ways to restructure the office. I know we've talked about community prosecution, but I do think we may need to pull some of those into different areas. And for example, the street response integrity crime prosecutor that I proposed, I mean, that's somebody I would move from a different unit over there. And sometimes I do feel if you go on a day-to-day around our courts, you'll find 4 prosecutors just sitting there waiting for something to happen in a courtroom. And that's just, that's not a good use of our time or taxpayer dollars. We need to figure out a better way to utilize our talent.
There's also a secondary question to this. What role would you give victims in the process of plea bargaining, if you wanted to answer that too?
Well, I think our office has always done a good job of giving victims a role in the coming to a plea bargain. Victims don't ultimately decide what we do on a case. It's the state of Texas versus the defendant. So we do weigh what the victim would like to see done in a case. And it depends on the crime itself, on how much weight I think we give that.
Anyone else want to finish?
I'll just say real quickly that plea bargaining is a necessary evil in the criminal justice system. We bring in 12 to 13,000 new felonies every year, and we still have cases pending on the dockets. But I agree with what's been said, that we need to make sure that we're concentrating on our core issues and trying those cases and making sure we see to the public safety on violent crime, child abuse, domestic violence, public corruption. We do have an excellent reputation with allowing victims expression. Victims are not parties to the lawsuit, but I think we have for many years recognized that when people are harmed in a felony, they need to be able to talk about how they feel and what they think ought to happen on the case. And we will continue to do that.
Anything for you, Rick?
Well, in terms of the issue of whether or not we have enough prosecutors, I think the answer to that kind of depends upon whom you're asking. If you ask the people in the upper echelon, they probably will say yes. If you ask the trial court prosecutors who are dealing with these cases on a day-to-day basis, I think you will receive a resounding no. The fact of the matter is that our trial court prosecutors are overburdened. They have a tremendous amount of cases that they have to deal with. That requires a tremendous amount of reading, a tremendous amount of trial preparation, speaking with witnesses, you name it. So I think that we could always use more prosecutors, but I think one of the ways that we can address that issue, given the fact that we do have finite resources, is to ensure that the resources that we have are being most effectively used. And I think that when you have a situation where you are taking some of those resources in a capital murder case and you are devoting them to seeking the death penalty, I quite frankly think you're wasting those resources, particularly when you have life without parole. Death penalty cases are a small fraction of cases that the district attorney's office prosecutes. And we have a lot of other capital murder cases. We have a lot of other murder cases, a lot of other violent crimes. And I think that it's important that we dedicate the resources that we have to the investigation and prosecution of all those crimes and not simply focus in on seeking the death penalty.
I think we're gonna do any good talking about them because most the police department, the DA office, they leave us out every time they have something. All the people, like people getting killed in East Office. And in the back, and like Chester's a block from me, Chester Club, everybody knows that 12 and a half hours. That's my grandson's best friend. Y'all just haven't done enough for the black people. for the police and DA. Y'all, you have the wrong people in the wrong place. They haven't been trained enough to know, understand us. We just having a big problem. I think this, sometimes you just put a person there because you like them. They don't know anything about us on this side of town. But you got to think best for everyone, okay? And I appreciate your comment. Thank you.
More comment, but if you want to respond, anyone? Okay. Should make sure. Do you want to talk about your view of your role at the Texas legislature? Every major county district attorney lobbies or has a representative to lobby at the Texas legislature to promote changes in the criminal laws of Texas, except Travis County. Will you actively participate in the Texas legislative process? If so, what standards will you use to decide which bills to support and which bills to oppose? Will you support state legislation that reduces the incarceration of drug users? Is a more specific question.
I would actively participate in any legislative discussion on any bills involving public safety. And I think it doesn't have to be a criminal law bill. It could be other bills involving public safety. And I think as a district attorney's office, you should be open in the legislature with a position, let them see how this affects us and how we can make it better. And what was the second part of that?
Oh, I'm sorry. It is just specifically, your standards that you would use to decide, but you kind of said that, I guess.
Again, public safety, but also you asked about...
Just incarceration, would you seek legislation that would reduce incarceration of drug users?
Absolutely, absolutely.
We do regularly participate, and I will. I see Andy Oyano saying no, so she obviously disagrees with me. We interact with TDCAA regularly on legislative issues, and it's my impression that we do, and I'd like to hear if there's areas that you disagree with, because that's what we're here for, to hear your complaints. I have interacted with the legislature, particularly on the Public Integrity Unit budget. There have been moves just about every time we turn around to try to take away the jurisdiction of the Travis County District Attorney, to send it to the AG or chop up our authority. That is one commitment I will give you here, that I will absolutely resist any move to take away the authority of the Travis County District Attorney to oversee public corruption cases in Travis County and statewide.
I do favor legislation that would reduce the number of drug offenders that we have in our prison system. I also am in favor of the district attorney's office being actively involved in the legislative process. The primary role of the district attorney obviously is to prosecute criminal cases, but when the legislature is in session, undoubtedly the district attorney's office has a vital role to play in shaping the laws that the district attorney's office is later going to be called upon to enforce. And I think it's imperative that we be involved in that.
Well, Ann, I've seen you down in the legislature, and we may not always agree, but I'm sure as heck there. And where are my counterparts? I'm the one down there who's testifying in every session pretty much since I've been a DA. And I took a I took a session from the DA's office on loan to the District Attorneys Association. Now, I did that with the permission, of course, and the guidance of the office. I was asked to do that by TDCA because I've worked in the legislature and I understand the process. And let me tell you, more importantly, I am constantly asked as the face of the Travis County DA's office, where is the Travis County DA? It is imperative when we are prosecuting public integrity cases that we have a presence and we are visible. They want our opinion. We need to give our opinion, and the DA absolutely needs to be the one down there day in and day out, as much as he or she can. I mean, obviously we've got an office to run, and you're going to have representatives go with you or go for you. But the DA needs to go down there. It's Travis County. This is where the capital is. We need to have a presence there, if not once a week during session, at least at the beginning and the end. And I've continuously been the one from our office who's been over there doing that. And so, of course, I would continue to do that. It's extremely important. The second part was, seeking legislation to reduce incarceration, sure. I mean, that's one of the things. I think you've got to talk to a consensus, much like we do with the death penalty. Get people from our office to the table to figure out what our position, and not just the office. We've got to talk to the community, and we've got to go down there together as a coalition. It's not just the Travis County DA's office, it's law enforcement, it's nonprofit agencies, it's neighborhoods. Why can't we have a Travis County coalition so that we can have a real presence at the legislature?
Okay, we're just going to have two more questions. One we received via email, and then one more from the audience. We've sent out various emails and blogs asking people for their input who couldn't be here. And one of the questions that came up was having to do with the Public Integrity Unit, and specifically people wanted to know about the Tom DeLay case and or if you had any role in the Tom DeLay case, what was your role, and what was I think there's been some newspaper articles, what was the discussion within the office about whether or not we should go forward, and just in general also about strengthening, using the Public Integrity Office. A lot of newspapers have said whoever's elected Travis County prosecutor is the most powerful district attorney in Texas, so
You can answer that in a minute.
addressing the question then of the Public Integrity Unit and how you would use that power as the most powerful district attorney in Texas to protect us against.
I'll go first to get my little part out of the way. I've never been in the Public Integrity Unit. I had no involvement whatsoever with the Tom DeLay case. But for me, it always comes back to this. Crime is crime. Whether you're investigating murder, rape, and robbery cases, or you're investigating public trust cases, you approach them with the same aggressive prosecution. You go forward with the evidence, you get the case indicted, you take the case to trial, and let the jury decide on what should happen with the case.
Anyone else want to respond?
I've been in the Public Integrity Unit. I was picked to work on the Trimpak and Tom DeLay case. It was an honor to do so. At that time, we didn't know what we had, or even if we had a crime, and we were very thorough. We were very deliberative, and the result has been indictments that you see. Now, whether or not we should discuss the specific discussions, I think that's counterproductive, because quite frankly, I think those discussions are very important. Regardless if it's a public integrity case, you need to have honesty and open discussions and not feel that your opinion is going to be plastered on the front page of the paper the next day. I mean, that's part of your freedom of speech, your ability to want to speak up, whether something should go to grand jury or whether it not. And if you feel it's going to be in the headlines the next day, you might not speak up, and that's a disservice to this entire community. And I'm not just specifically mentioning Tom DeLay, although that's the buzzword these days. So number one, I don't believe, I think your question was what your role in the case was. Well, as an office, we're the face of that case. But there were some of us in that Public Integrity Unit, two of us specifically over there in the unit at that time. Of course, Rosemary was the first assistant, so she supervised. But we had a part in that case, and what our specific role is, again, as an office, we brought those charges.
I was involved in the investigation of that case and the presentation of the case to the grand jury. And while on the one hand, I understand there's an argument to be made that certain discussions that take place behind the scenes prior to the presentation of a case to the grand jury should ideally not be on the front page of the paper. I think that when arguments are advanced regarding whether or not to present a case to the grand jury, arguments that are, in my judgment, improper, I see no problem with making that public. In fact, I think the public ought to know about it. If, for instance, the argument had been made that we should not present Mr. DeLay's case to the grand jury because he's a white male, I think that's improper, and I think the public's entitled to know about it. The argument that was made was that we ought to be reluctant to present this case to the grand jury because of the fact that this was a very powerful individual, a House Majority Leader, and that ought to be taken into consideration. It was my belief then, and it's my belief now, that that's not a legitimate consideration when it comes to the decision whether or not to present a case to the grand jury.
I'm going to finish this. My role with Ronnie Earl as first assistant was and is to help him make decisions at the highest level. And I will continue to do that until and if I'm elected district attorney, and I hope I find somebody like me that will sit down and talk with me, like I talked with him, about cases, not just the Tom DeLay case, but every case that comes to his attention. I think Rick does not understand, we had different roles. We had very different roles. He was working on briefs, and he was working on appellate points, and he certainly was a part of the discussion, as was Mindy. Mindy worked on that case for a period of time. But I worked with Ronnie from the beginning of that investigation until now, and I will tell you those cases are pending. We're not going to talk about anything other than the fact that we're going to go to trial, almost certainly, on some of those cases. But as far as my role in that case, that's what I did. I'm going to continue to do that. And I think it is wrong to try to talk and to misconstrue what my role in that case was, to talk about the pros and cons of the prosecution. That's what I'm for.
Okay, we have one final question. Stephanie?
Hi, I'm Stephanie Collins, and I'm on the board of the ACLU, and I'm also a third-year law student, and when I grow up and I'm not a baby law student anymore, I'm going to be practicing criminal defense, so that'll be fun. One of you guys' future employees will be my courtroom nemesis, but that's okay. I won't hold it against y'all. I wanted to ask one question about, we already talked a little bit about use of the death penalty as it's currently on the books, but I also wanted to ask all of you all about the possible expansions of the death penalty. I know, Mindy, you testified in support of Senate Bill 5 to expand the death penalty. Would you, or any of you all, be in support of, spearhead the fight for expansions of the death penalty to further crimes? And then secondly, I also, more generally, to all crimes that you all are going to be prosecuting, how are you going to handle physical evidence? And I know that that's a broad thing, but basically what I want to know is how do you propose that DAs, assistant DAs in your office, be educated on methods of physical evidence collection, methods of analysis, so that they know about pitfalls in the physical evidence, especially some kinds of forensic evidence, and how those are not as, some have extreme factors of unreliability associated with them. And how do you propose that the DAs in your office know about these things? How do you propose that they, what do they do with their doubts when they start seeing, that their experts are telling them things that may not make very much sense in line with the rest of the case? And how do you go about reopening cases where you've already obtained a conviction? We know that, the jury system is the best in the world, but juries sometimes get it wrong. It doesn't always end with the jury process. So when somebody has been, in fact, sent to the penitentiary or put on, paper for a piece of physical evidence that is starting to look, worse and worse in light of maybe bad testimony from the medical examiner, like Ray Vallardo, things like this. What happens to those cases when you guys start getting the inkling that something went wrong, especially in terms of medical examiners' offices?
Those are all take on each.
I'd like to start because, first of all, the fact that I testified for the expansion of the death penalty is completely wrong. I believe you're talking about Jessica's law, and I believe we went on and clarified that. I thought they were going to issue a retraction on that because what happened, and there's a tape recording of my testimony to back it up, I was asked by Ronnie Earl, once again, to go down and testify at the Capitol against that bill. And so if you go back and listen to the testimony, I'm actually there against it, as most prosecutors were that day on that particular issue of the bill. So I know that's how it's reflected on the cards, but that's not correct if you go back and listen to the tapes. And I believe we sent the tape over and it was retracted. But it's a fair question. Physical evidence, how we handle it. I probably would like to have it in writing because you had a lot of great issues in there and some good points. But I think that the Dallas County DA has taken control of those cases and said, you know what, first thing we're going to do is go back and review those and make sure that those people were properly convicted. And I have no problem with following that. I think he's one of the first persons I probably want to meet with once elected.
And I want to clarify, are you talking specifically about cases involving DNA evidence and actual innocence? Is that?
Well, I mean, not just DNA, but things like arson, arson evidence. We are finding out that the arson evidence that we used against people 20 years ago, those methods are not as at all reliable now, much less reliable than
Right.
they were.
Okay.
So things like that.
Sure, and I have said that there's actually nothing more horrifying as a prosecutor to find out that someone that you've convicted was innocent, and it happened all over the nation. It's awful. But when DNA evidence became available, that started happening. And what we did as an office, after it happened to us, was we went back and pulled every old case and reviewed it as a committee, a big committee. Spent hours and hours going over and determining in which cases there was actually a claim of actual innocence where someone had been convicted and where DNA evidence was still available. And we had that evidence tested on we looked at hundreds of cases. There were a lot of prosecutors' offices around the nation that just shut down, opposed motions, and just kind of stuck their head in the sand on that. And we really didn't. We developed a protocol for that and said we're not going to sit by and let this happen again without at least looking to see what may be out there. And we spent a lot of time on that. Gary?
Addressing the first issue that you have with the expansion of the death penalty, I would not be in favor of expanding the death penalty, especially if what you're talking about are cases that involve someone not being killed as part of an aggravating factor. Like in Louisiana, where they have, if you committed a sexual assault and then you commit another sexual assault, you can get death for that.
Well, here in Texas, we have the same kind of law.
Well, they have the cases up in front of the Supreme Court right now with it. So totally against that, because I think all it does is encourages a murderer to commit a murder and eliminate the witness. As far as the handling of the DNA evidence, again, it goes back to training. We should always train our prosecutors about handling evidence in any state, but that's not really that big an issue because the prosecutors aren't out there collecting evidence. We have crime scene technicians that do that. So by the time it gets to court and we start to look at the evidence, it's not a contamination issue. We have a system in place for what we do with it after a person is convicted to make sure that during the appeals process and forever and ever after, that evidence is available to be looked at again, and all throughout, we would not oppose anybody looking at it. But let me also add to that. Sometimes guilty people are actually convicted, even though there are people who disagree with their conviction. So don't make it seem like there's a lot of people out there who are being convicted because there are renegade prosecutors out there, renegade grand jurors, and crooked judges, and crooked cops. The system works pretty well.
Yeah,
and hold on just a second. And I'm proud to be a part of that system. I'm not trying to apologize for any of that, but we all realize that it's a system that involves a great many humans. And some of those people are doing wrong. And we try to catch them if they're doing wrong, and we try to correct any mistakes that have been made at any part of that. But it will always be an imperfect system. And there's no way to make it perfect or to make everybody happy.
Sure, I wasn't meaning to characterize any person having malevolence, in their intentions, but sometimes things just don't. We find out later, 10 years later, or 15 years later, that the method used to convict somebody just wasn't very good science. It turns out, and so the DA's office sometimes across the state. Wait on defense attorneys to instigate investigations, reopen convictions. But a lot of, a lot of people that have already been incarcerated, their best lawyer is the jailhouse lawyer in the next cell because they don't get appellate attorneys they don't get appointed appellate attorneys. So can you all take the initiative to reopen some of those cases where the physical evidence might have been, in fact, mischaracterized or misanalyzed?
But what you would be asking is not at all realistic.
No, I'm not asking that. I'm not asking that. I'm asking whether the physical evidence is in serious doubt. The method, like in arson investigations, that's a prime example. Arson investigations are, the methods people were convicted on 20 years ago are not good science anymore. It's not.
Satanic child molestation, name another one.
Let's let Rick finish answering this question here, and we'll tie up.
Well,
the microphone, Rick.
do need to be reminded of that. A few moments ago, Gary said that the system will always be imperfect, and that's true. And that's really at the core of this issue involving the death penalty, because no matter what we do, no matter what sort of advances are made in technology, in the final analysis, 12 jurors are going to be making a decision whether or not a particular individual committed a crime, and they're going to be making a decision about whether or not that person ought to be executed in a capital murder case where the state's seeking the death penalty. And regardless of advances in technology, there's always going to be human error that's going to be a part of the process. Once we've executed somebody, there's no way of going back and correcting that mistake. So I not only oppose expanding the death penalty to cases beyond capital murder, I'm opposed to seeking the death penalty in cases involving capital murder, particularly given the fact that we now have life without parole.
Okay. All right, thank you everybody. I want to wrap this up in 30 seconds. For those of you who didn't get your questions answered, if they would be so kind and allow me to send them a few more questions by email, and maybe in a week's time we can post that on our website, come to aclutx.org, go to the Austin page, email me your question. I'll compile them and send them. We'll send them 5 or 6 questions tops. We had some other good ones that came in that I would really like to see what their answers are. And if you didn't buy anything from Jean, visit the tip jar on the way out. Thank you, Jean, very much for hosting us. I appreciate it. Thank you so much. I'm so glad to see this turnout tonight. I'm sorry it was tight quarters. I wasn't expecting quite the reception. This is great. And thank you, candidates, for joining us. And bearing with us.
I need to nurture my soul. Really important. Evenings too? I see. But she's really trying to
I'm not happy.
Absolutely, they did not answer my questions, with the exception, of course, of Rosemary. In fact, answered my question, and it showed fairly clearly that she's absolutely unfit to hold any sort of elective office on the face of this earth. She is in charge of that unit of the Travis County District Attorneys, and she doesn't remember the accusations of digging up baby bodies and playing with the bones and then reburying them to where there wasn't any evidence the next day. Come off it, woman. I don't buy that for 1 second. According to Debbie Nathan, there's something like 400 people still behind bars in this country because of that satanic child molestation bullshit, and I'm profoundly and deeply embarrassed to live in a county where there's a pair of people who committed no crime who are going to spend the rest of their lives in prison because of that evilness. Because it's not just wrong, it's evil.
Sir, I feel it was an excellent forum, although not quite long enough to address all the issues necessary for the district attorney's race. There's a lot of things that need to be addressed, and I look forward to the additional answers forthcoming in the next few months. But I think that a lot of information was brought forward, and a lot of their stances on certain issues have been brought out to help people make an intelligent decision.
Well, I thought it was a great forum. I'm glad that the ACLU had a forum, and I'm glad that all 4 candidates were willing to come out and talk. I thought it was a good forum. There were a lot of good questions. As politicians always do, our candidates, they're very careful in how they answer the questions, which in a way is good, but sometimes, there are parts of the issues that they kind of work around, dance around. I really like what Rick was talking about, being against the death penalty. I think that's extremely important. I don't think any of these candidates are enthusiastic. Nobody in this group likes the death penalty, but I wish they were all willing to say that they just wouldn't use it. I think the public integrity unit is very important, and they did address that. There was quite a bit of, there were quite a few questions that had to deal with that, and they talked about that quite a bit, which I thought I was very happy to see that, because I think that's one of the very most important things that the Travis County District Attorney does.
I think Gary is the most qualified prosecutor in this race. He brings a lot of really good qualities. He's going to be very fair, very understanding, and I think he's going to do what's right and what's needed.
Well, I like Rick Reed because he seems like the most honest and the most down to earth about what exactly DAs can do and what they can. I mean, especially on that last question, if you listen to the other candidates talking about imperfections in the system, it seemed like they were all just basically asking us to just accept it. It's like, well, it's just always going to be messed up. There's not very much we can't make enough changes to finally make it perfect. So just accept that there's imperfections, that we make mistakes, just get over it. But Rick Reed's answer was actually about how people shouldn't be in the position to make mistakes that they can't correct later. I guess I just liked how Rick's answer seemed more conscientious, more self-aware, that everybody makes a mistake, but if you execute somebody, that mistake can't ever be corrected. And the others seem to just have a way more cavalier attitude about what the DAs can do to correct their mistakes later. And none of them answered my question at all about the arson evidence. I mean, well, Gary Cobb, even dodged the answer by saying that I was asking him to reopen every single conviction, which is just not the case at all. But I think, people who've been convicted on physical evidence, on, methods and testimony, the facts that we know don't even make sense anymore, like the case with Cameron Todd Willingham. There's people throughout the state that have been incarcerated for crimes less than murder that involved arson on the same damn evidence. And it seems like, Gary Cobb just basically, instead of answering the question honestly about what could actually be done, he just basically made fun of the fact that I was even concerned about it, And he also seemed to have the most, tough on crime rhetoric, sort of differentiating violent crimes from everybody else. But innocent people go down for violent crimes too. It's not just drug offenses that innocent people go down for. It's these big time wrongful. The worst wrongful convictions are usually the ones that involve the most violent of crimes, not the other way around.
Okay, the United States is 5% of the world's population and contains 25% of the entire world's prison population. You tell me that's some sort of success? This is crazy.
The public had a chance to hear and see the four candidates who are running to be the district attorney. There are some very hard questions asked, and there were some relatively easy ones. I think the audience was engaged. There were some people who expressed a great deal of outrage at some past inappropriate or insufficient actions by the district attorney. The question was brought up about the district attorney's relationship to the juries. Brings up a whole question, which didn't really come here, about how to regulate juries. Makes me think of that. And that's, so some questions were brought up to here that can be tackled at another time.
Hi, I'm David Koborowski. I'm on the board of directors of the ACLU. We had a great event here today. It was at Poor Boys, Jean's Poor Boys here in East Austin. My concern is that I wish one of the answers that one individual, I think it was Mindy, that had mentioned that she spends a lot of time at the state legislature. I do wish that the DA would spend more time putting pressure on the state legislature to actually pass the correct laws to encourage individuals to have rights out there throughout the community. I look at that as an opportunity for the DA to push back on the state, get more involved, and be able to enact laws correctly.